90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Kenneth Landau, and welcome to Law You Should Know. My guest today is Immigration Attorney George Terezakis, and he is the chair of the Immigration Law Committee of the Nassau County Bar Association, and he's been representing people from all over the New York area on immigration matters and also fighting deportation for them and defending them in criminal matters for over 30 years. George, welcome back to Law You Should Know.
Thanks very much, Ken. It's great to be here at Nassau Community College and have this opportunity to speak with the community.
And you'll mention a few tips in Spanish for anyone who is English is not their native language, so they can pick up some points. And we read about in the news, and we don't know what the status of it, but everyone's worried about dealing with ICE and potential deportation or removal from the U.S., even of law-abiding people and hardworking people. So let's talk about what people can do to avoid that possibility or fight deportation if they should be picked up by ICE.
Sure, Ken. Generally speaking, there's different ways that people who aren't citizens come in to interact with ICE or come to the attention of ICE. One of the most common ways is when they apply at a border or a port of entry. Sometimes a person may apply for admission, but their papers aren't in order, or they have some kind of false or altered documents. That could subject them to what we call expedited removal, where they don't even go in front of a judge. They're just immediately held and removed from the United States or turned back. Also, what's very common is enforcement at the border where someone has status as a lawful permanent resident, but after they were granted that status, they came involved in the criminal justice system and then have a conviction for a crime which makes them inadmissible, which means if they travel outside the United States and when they come back and the Custom and Border Patrol agents run their passport, check them in the database, they may see the person has an arrest or a conviction, and based on that, they may be held, deemed inadmissible, and placed in deportation or what they now call removal proceedings before an immigration judge.
And if someone's held at that situation, is there anything that you as an immigration attorney can do?
Yes, Ken. The person always has the right to be represented by an attorney if they're placed in removal proceedings. People who are placed in removal proceedings when they're at the border and are deemed inadmissible, it's very difficult because if they have certain criminal convictions, they may be found to be subject to what we call mandatory detention. And that would mean they would be ineligible for bond. Many times as a lawyer who defends these cases, we fight before the judge on legal points, whether or not a particular conviction may actually render someone subject to inadmissibility. Sometimes they're charged as being inadmissible when in reality they're not.
And sometimes they need a lawyer to help clarify that mistake.
Exactly, Ken. These are very, very complicated laws. It would be like a massacre in most instances for someone to try to defend themselves in immigration court where there are criminal convictions, where they're alleged to be inadmissible, because they just don't know the law. Also, Ken, to give you an example, even a conviction for a non-criminal violation of a possession of a very small amount of marijuana, even a conviction for smoking marijuana in public, would render a non-citizen, even a permanent resident, inadmissible to the United States. And that could result in their detention, and it could result in their deportation.
And that's why you mentioned another program. It's always better to go from resident green card holder to citizen if you can.
I can't tell you how many clients I've had over the years, good people, working people, who've maybe made a mistake, or maybe in their past, when they were younger, made several mistakes, and everybody else in their family naturalized, but they didn't. And one day, after they've been making trips to visit their home country or going on vacation, they're stopped at the border by Customs and Border Patrol. They're taken to a small room, which is referred to as secondary inspection, and all of a sudden they realize that their life in the United States may be subject to being taken away from them, and they could be deported, separated from their family, their job, their home, their business, the people they love.
And if they were eligible to become a citizen and they did not take advantage of it, they would skip all that.
Yes, Ken. If someone had become if someone became eligible to naturalize and then naturalized and then later committed that small offense of smoking marijuana, or perhaps a more serious offense, if they're a naturalized citizen, before that happens, they would not be subject to deportation or removal.
Let's talk about ICE, how ICE enforcement works within the U.S. We've heard a lot of stories on Long Island, New York City, and around the country of people being rounded up by ICE.
Ken, there's many different ways non-citizens come into contact with ICE. There's different types of enforcement. Under President Obama, primarily the enforcement was geared toward individuals with criminal convictions. And it was a determination that based on using government resources, there was a determination made that it made the most sense to focus on people who had criminal records that presented a threat to the security of the United States, arguably. Sometimes some of those people had, like I used the example of marijuana violations, relatively minor things, but irrespective, the general preference was enforcing cases where people had criminal convictions. But now, in the current administration of President Trump, although they talk a lot about deporting people with criminal convictions, there's much more widespread enforcement and removal of people who have no criminal records, even where they have children in the United States, even if they're married to a U.S. citizen or have permanent resident children.
It's really a paperwork or status violation.
In those instances, they're really just not in the same category of people who may have much more serious convictions, and it's really heartbreaking to see how that happens.
So let's talk about some of the places they may go to. They may go to a person's home. They might go to a court while they're in court for another manner before they've been found guilty of anything, or perhaps when they check in to do whatever they have to do for an appointment with ICE as to their status.
Yes, Ken. Although ICE is still picking up people who are simply undocumented, a lot of their enforcement efforts are directed at people with criminal charges or with convictions. So what that triggers the contact with ICE. So it's not at all uncommon for ICE to, if someone's been arrested and they're held before they post bail, to file a detainer with the local jail, which means they'll be held until ICE picks them up. Another way is if someone's been convicted and sentenced to probation, when they go in to report to their probation officer, sometimes ICE could pick them up.
And they could have problems because of that conviction.
That's correct, Ken. Some convictions may render someone who's a lawful permanent resident, even if they've been a resident for many, many years, subject to deportation. Also, for people who've been in this country for many years, in many instances brought to this country as young children by their parents, people who've grown up in this country, gone to school in this country, worked for many years in this country, raised a family, a simple encounter with the criminal justice system, for example, an incident of smoking marijuana or
a traffic stop.
A traffic stop could lead to ICE involvement, could lead to that person being detained and placed in the deportation proceedings.
So if they're in that situation, they were picked up at a traffic stop, there's some problem with their paperwork, can someone like you help them try to stop or slow down the proceedings?
You know, Ken, in this country, thank God, under our Constitution and under the immigration laws, there are many, many procedural and substantive rights available to protect the rights of all people, and especially and including immigrants. And that includes whether they're documented or undocumented. And unfortunately, many times, especially people who've never been involved in the criminal justice system, or maybe have relatively minor violations, they get picked up. Many times ICE comes to their homes early in the morning when they're on their way to work, or in the evenings when they're returning from work, and picks them up, takes them to a detention facility, processes them, holds them far from their family. If you're picked up by immigration here on Long Island, they actually hold you in detention centers in a jail in New Jersey, either in Hackensack or Kearney at the Hudson and Bergen
they can
County
wear
jails.
these people down. It's almost like psychological warfare.
You know, Ken, it used to be that, let me rephrase that. Under the immigration law, in general, you're entitled to a release under bond while you're in deportation proceedings, unless you have certain types of convictions. And in the past, it was very common when someone was brought in, especially if they'd been in the country for a long time, had no criminal record, had family members here like a U.S. citizen spouse or permanent resident spouse, they had children. The deportation officers, they were called then, now they're called enforcement and removal officers, they would look at the person's background, set a bond, and they'd release the person, sometimes the same day, and give them a date to come back to court because they had long-standing ties in the community, no showing of violence. But now, since President Trump's been in office, they not routinely, in virtually every single case that I've seen, the deportation officers are not setting bail, and they're holding people and requiring them to go in front of an immigration judge and make an application for bond.
And you could help them with that process.
We can help them with that, Ken, and it's very important because, as you said, it's a lot of pressure on someone.
And that's the last best hope, because if they don't fight for that, they could be incarcerated and moved around and further away for a long time.
Yes, Ken. And unfortunately, sometimes, and it's not always, but sometimes there may be ICE officers who tell a person, you know, there's really nothing that can be done for you. You're going to pay a lawyer a lot of money, and you're still going to get deported. You're going to be held in the jail here in Bergen County or in Hudson, and you're not going to be able to be released, and you're going to lose your freedom. In the end, you're going to be deported. There's nothing anybody can do for you. And that's really not true in the vast majority of the cases.
I just want to remind our listeners, you're listening to 90.3 WHPC, the voice of Nassau Community College, and we're listening to George Terezakis. He's an experienced immigration lawyer doing family immigration and also helping people to fight deportation. And he's also the chair of the Immigration Law Committee of the Nassau County Bar Association.
Ken, it's very important in those cases that a skilled and experienced immigration attorney can have their client released under bond, then go forward and apply for applications for relief. We've had cases where someone came to the United States on a student visa, on a tourist visa, and then fell out of status, became involved in a relationship, a true relationship. I've had clients that were, ICE came to their door at 6 o'clock, 6:30 in the morning, and their wife opened the door, and their children were in the home, and they were taken away, and they can show that if they marry, that they had a pre-existing bona fide relationship, they simply never married. And so even in front of an immigration judge, they can apply to adjust their status and become a permanent resident.
So if they had like a common law marriage?
Correct. If they had a common law marriage and then formalize it with an actual marriage, and then there's a petition that can be filed, and they can, in certain instances, apply to adjust their status before the immigration judge. Also, Ken, there's a humanitarian provision in the immigration law so that if someone's been living in this country for at least 10 years before they're picked up and placed in deportation, if they don't have any criminal convictions that would disqualify them, and if they have a qualifying family member, a U.S. citizen or lawful permanent resident, parent, spouse, or child, and if they could show that qualifying family member would suffer what's referred to as exceptional and extremely unusual hardship, not only will that immigrant not be deported, but they'll be permitted to remain in this country to take care of their family members and gain status as a lawful permanent resident.
If someone, let's say they may have a criminal violation, but they're out awaiting adjudication, or the police are looking for them, as opposed to ICE, should they work out with you to lawfully surrender to the police so to keep whatever their legal problem is from getting bigger?
I always believe that if someone is facing criminal charge, it always makes sense to retain an attorney, arrange for a voluntary surrender. It'll help the person with possibilities for release under bond to show that they've surrendered themselves voluntarily.
And to get best possible resolution of that.
I think it always works best that way.
But not for ICE. You're not going to voluntarily surrender yourself to ICE for the reasons you mentioned.
You know, Ken, in certain instances where we know ICE is looking for someone, they're pursuing them, we have arranged to have someone come in and voluntarily surrender. But I think it's important that whenever someone has to make these decisions, that they do so with the benefit of counsel. For example, when we're talking about the example of people going before an immigration judge and exercising their rights, someone who's been a lawful permanent resident and they may have committed an offense after they've been living in this country for a certain period of time, they may be eligible for what's known as cancellation of removal. And I've had many, many cases where someone, especially it seems when they were younger, may have committed an offense, whether it was a drug-related offense, a simple possession, or some larceny cases, or maybe something more serious, maybe even an assault or something like that. But the person's gone on to change their life, and they can show to an immigration judge that they've been living a lawful life, that they've truly rehabilitated themselves. They have a chance to go in front of a judge, and the lawyer will present the case on their behalf, show the hardship that they would sustain, the hardship to their family, the good works they've done, and a judge can give them one chance to remain in the United States. And that one chance can mean the difference between remaining in the U.S. with your family, keeping your business and your home and all the people that you have your friendships with, or being sent back to a country where in many instances the person hasn't been for 20, 30, 40 years. They may have come here as a child and not even be able to speak the language. So it's critical to have that representation, Ken.
And George, just take a moment to tell us in English and Spanish about your website, which contains additional information.
Thanks very much, Ken. We have a website, and you can find it very easily. It's at nassawdefender.com, or in Spanish, sudefensor.com.
And the Spanish website would have the information in Spanish.
Yes.
Can you also help people, if they haven't already made it and there's some basis for doing it, to make a claim for asylum, or maybe seek a visa as or some kind of special consideration as a victim of domestic violence or a crime victim or something?
You know, Ken, for someone who's not an immigration lawyer, you're pretty familiar with some
I
of
do a
these
lot of
other,
radio shows.
Some of these other provisions of the law. You know, Ken, asylum is a very, very important law. It's based on treaties that the United States is a party to, including the Convention Against Torture. And basically the rule of law, stated simply, is that we, as a civilized country, do not return people to countries in which they face persecution. We don't send people back to a country where they could be tortured, where they could be killed, based on their race, their religion, their political opinion, their membership in a particular social group. There's grounds for protections. And unfortunately, recently, the current administration keeps trying to cut back and deprive people of the ability to come to the United States and seek refuge. And personally, I find it very shameful and inhumane. And yet, in many, many instances, there are people who, for example, now it's very common, individuals fleeing repression in Venezuela or even in Nicaragua, applying for political asylum. We have people coming seeking safety in this country who've been subject to persecution by gang members in countries such as El Salvador, Guatemala, and Honduras. These countries have some of the highest rates of violent crime and murder in the world. And I recently had a client who'd been shot 7 times by members of one of these street gangs, the Mata Salvatrucha, MS-13, and that individual couldn't find safety in their country. The police were not able to help him, were not interested in helping people like him, young, poor men, and ultimately we were able to provide protection for him and save him from being sent back to his country. So it's very important that individuals, if they come to this country fleeing persecution, that they apply for asylum within a year of entering the United States.
If someone, let's say they're already in the New York area and they don't have proper status, if they have been a crime victim or a witness to the crime or victim to domestic violence or perhaps slavery of their employee or not paid their minimum wage or a witness to some kind of crime, can they obtain special protection or a special visa?
Yes, there's a U visa that's available for people who've been victims of certain crimes and who cooperate with the authorities in prosecuting those crimes. And the rationale behind it is law enforcement, the local police, the Nassau County, Suffolk County Police, the local police don't want immigrants to be afraid of coming forward and assisting law enforcement in prosecuting individuals who commit crimes. And so the process would be they would apply to be certified once they've actually assisted law enforcement, and then once they've been certified, in the future they will be able to actually apply and become lawful permanent residents.
So rather than a fear going to the police if they were a witness to the crime or they were a crime victim physically or economically or, let's say, in a domestic situation, you could help them make sure they get that protection that would go along with cooperation.
Yes, Ken, we've done that in many, many instances and helped many people who have been crime victims. And it's for that reason, Ken, that a lot of the local police don't want ICE going out on enforcement details wearing jackets that say police on the back. They want them to wear something that says ICE. Unfortunately, many times ICE will come to a door. They may say that they're the police. They may say they're looking for a particular person that they know doesn't live in that house, only to gain access.
So I know, and one of the things I know you want to discuss is what should someone do if ICE knocks the door? Let's assume they don't have a reason to break it in. Should people not cooperate, not talk to them, not let them in the house, not give them information about other people?
Ken, my experience is that a non-citizen always best served if they can reach out and contact an attorney. And they should reach out to one even before they have a problem so that they have some place to call, whether it's a private lawyer or a not-for-profit. But my general advice is you're not obligated to open your door and let ICE in. The only time that they can come in against your will is if they have a valid warrant signed by a judge that allows them to do that. Unfortunately, ICE in many instances intimidates people. We've had many cases where they show up at someone's door 6 o'clock, 6:30 in the morning, banging on the door. Some child may come and open the door or someone who's just stumbled out of bed. And then once that door's open, they come through.
Or a roommate or a relative or a guest or a friend.
And they may go through and search everyone in the house. And we've had many instances where people have been taken from their homes based on that type of a search. I feel the best policy is if they don't have a judicial warrant, don't let them in. If an individual, whether it's a family member or the person who is themselves an immigrant, that maybe ICE is looking for them either because they're out of status or because they have a deportation order or conviction, I would just say, whatever you do, do not make any false statements. You can exercise your right not to speak, to remain silent, and seek the assistance of an attorney.
So while they're interviewing you, even if it's about someone else or about you, your activities, you can have an attorney present.
You should request an attorney, and I believe that person or their family members should simply ask for the card from the law enforcement person, not give a statement, and state they'll only speak with counsel
and
present.
It's never good to lie to them or make a false statement.
To make
in writing or in person, in verbally or in
Ken,
writing.
That's absolutely true. If you make a false statement, even though you're trying to protect a child or a spouse, you can be charged criminally for that. And that's why the best thing to do, not to speak without your attorney being present.
And again, we're talking to George Terezakis. He's a very experienced immigration lawyer based in Mineola. He handles cases all over the New York area. He's also chair of the Immigration Committee of the Nassau County Bar Association. George, just give us your website in English and Spanish one more time.
Our website is nassawdefender.com or sudefensor.com. Our office, we all speak Spanish there. We're all bilingual.
And you can even arrange to help get translators for other languages, too.
Yes, we can.
I didn't mean to cut you off.
That's fine,
okay.
Ken.
And
we're there to help.
Okay, and I'd like to remind everyone you're listening to 90.3 WHPC, the voice of Nassau Community College. If you missed any part of this program or want to tell someone else about it, they can listen to the podcast at nccradio.org. Please join us at this same time next week for another program on Law You Should Know.